Okay, this is Rudy, January the 28th, and I'm going to read, looks like a conversation between the prosecutor, Mrs. Heldmeyer, and the judge, Judge Margaret Casey Rogers, before sentencing. And this is after Kent Hovind makes his last statement. And if there's any mistakes, those are my fault. I don't claim to read perfectly. I do the best that I can. And here goes. The court, thank you. Ms. Heldmeyer, do you wish to address the court as far as sentence? Ms. Heldmeyer, Your Honor, we spent 2 weeks at trial rebutting the comments and the ideas that Mr. Hovind still clings to. The basic information is in the record, and I don't intend to reiterate all the proof that we so diligently presented to the jury that found Mr. Hovind guilty. The only fact that I recall Mr. Hovind saying that may not have come out at trial, so I'll put it on record. Mr. Hovind repeatedly said that there was a grand jury that refused to indict him. That is not true. There's never been a grand jury that refused to indict Mr. Hovind. He was indicted the first time the indictment was presented to the grand jury. Other than that, Your Honor, I think that everything he says has been rebutted. The tape recordings show the lack of sincerity of any statement that Mr. Hovind could make to the court today, saying that he is sorry for anything that he has done. If he truly were sorry, if he truly wanted an opportunity to make things right, he had more than enough opportunity, and he could have most definitely have at least made some effort to pay the bill that he owes, and he has absolutely done none of that. I think the court knows what is truly going on here and knows what truly is in Mr. Hovind's heart, and the fact is that Mr. Hovind still has not learned and still does not accept responsibility for what he did. He does not accept responsibility for the harm he has done, he does not accept responsibility for the harm that he has done, not the government, to his friends and his family. And we ask that an appropriate sentence be fashioned in accordance with the guidelines. The court, all right, you had mentioned earlier an upward departure. Is that something that you are requesting? And if so, would you address that? Ms. Heldmeyer, Your Honor, the information that was presented with regard to the tape recordings that we presented to the court, there was information there that the court could use and find it that had not been taken into account in the calculation of the guidelines. The fact that Mr. Hovind is continuing to try to hide assets so that the IRS can't come and take them, the fact that he continues to threaten lawsuits, that he continues to threaten illegal means as retribution for what he apparently deems to be wrongs against him, all of those things, particularly the hiding of assets, Your Honor, the timing of all this, those telephone calls have been over the past couple of months after he found out what his sentence is, that the presentence investigation report says, after he found out about the preliminary order of forfeiture, and he even refers to them on some of the tape recordings. He even actually says on tape recordings he wants to do this. He wants to allocute and put all this on the record so that it can be part of his appeal, part of the appellate record. And my suspicion, based upon that, is the reason why he's addressing the court in that manner is not for the reasons that he's suggesting to the court, but is subterfuge, because he wants to use that as proof of facts that he wants to appeal down the road. So I don't even think that was genuine on his part. I think all these things that we've presented, Your Honor, give the court the ability to fashion a sentence above the recommended guidelines, range pursuant to the presentence investigation report, and we trust the court's discretion to fashion a reasonable sentence. The court, all right, is there anything else? Mr. Ritchie, no, Your Honor. The court, all right, I'm going to take a recess and meet with the probation officer. Mr. Ritchie, I know you have a plane to catch. It shouldn't take long. Once the court resumes to pronounce sentence, I'm going to take 20 minutes, and I think you'll still be able to make it to the airport on time for your flight. Mr. Ritchie, thank you, Your Honor. The court, we'll be in recess until 1:20. Recess. The court, Mr. Heldmeyer, what is the amount of the restitution? Mrs. Heldmeyer, the restitution, Your Honor? The court, yes, the restitution. I thought there was some change. Miss Heldmeyer, the bill of cost we are talking about now? The court, no, the restitution. Miss Heldmeyer, we made no change to the restitution amount, just to the government's bill of cost that was filed yesterday. The court, all right, what was the change to that? Miss Heldmeyer, the change, Your Honor? First of all, we were going to be withdrawing the bill of cost regarding Miss Hovind because Miss Hovind was not convicted of any tax charge, and that was was what prompted us to make a couple of small changes in the bill of cost. Specifically, there are two sections on page 3 of our bill of cost where we are charging the copies of Jenks material to both defendants. So we've cut those two amounts in half in paragraph 4, from $50 to $25, from $2,600 to $1,300. So the final amount that we're asking for the cost is $7,078.24. The court, as to the restitution and the amount reflected in the presentence report, is accurate? It is, Your Honor. The court, Ms. Heldmeyer. It is, Your Honor. The court. Let me address the issue, the matter of acceptance of responsibility. In order for someone to be entitled to an adjustment in their offense level for acceptance of responsibility, the person has to truthfully admit the conduct which compromises the offense of conviction. This has not been done in this case, and it is quite rare for it to be done in any case in which a defendant goes to trial, but I have taken it into consideration. But after hearing the tapes from the jail, and also the allocation that was made, I find that Mr. Hovind is not entitled to the acceptance of responsibility, that he has not accepted responsibility for the conduct which comprises the offense of conviction, which is what the jury found him guilty of. All right, let's then make sure we are all on the same page as far as the guidelines. The total offense level is a 30, a criminal history category of 1. Guideline range is 97 to 121 months. Again, the statutory maximum under counts 13 through 57 has changed, and that is 5 as opposed to 10 years. All right, let me make a few things clear before I impose sentence in this case. First, I want you all to understand and be clear on the fact that this case is not and has never been about religion. It was Mr. Hovind, not the government, who injected religion into this case during this trial. And I know the courtroom is full today. It's packed, and most, if not all of you, were not here for the trial. I do not believe. Some of you may have come in and out, but we certainly didn't have this number of individuals in the courtroom every day listening to the evidence, as those of us involved in the trial did here. Churches are not exempt from withholding and payment of taxes and the wages of employees. Pure and simple. That is a law. That is a law in this country, and it is a law that has been upheld by the United States Supreme Court. Who in this country has the final word on matters of law and the Constitution? Second, Mr. Hovind, Mr. Hovind is responsible for his actions in this case, and he, not the government nor the court, is to blame for what happens to the CSC ministries while Mr. Hovind serves his sentence. Mr. Hovind is the one who has caused the hurt and confusion that has surrounded these charges by refusing to accept the law in this case. Again, I know that most of you were not here for this trial, and most of you will not like what I am about to say. But I am telling you that this picture that Mr. Hovind painted during his allocution is not the evidence that was heard by the jury in this case. And we proceed at the sentencing based solely on the verdict of the jury and that what was presented here at the sentencing. Instead, the picture that was presented to the jury at the trial in this case of Mr. Hovind is completely consistent with what you heard today on the tapes made in the jail cell or from the jail, the most recent of which occurred just 4 days ago or Monday. Mr. Hovind, you stood before the court, and I listened to you. You spoke eloquently before the court and before your family and your friends, and you professed your confusion and frustration over and with the Internal Revenue letters. Okay, I'm going to stop here and start again at this point.